Hello guys, this video is on delegated legislation, its historical background, its constitutionality and its classification. So let us begin with what is delegation. Delegation according to Black's Law Dictionary has been defined as an act of entrusting a person with a power or empowering him to act on behalf of that person who has given him that power or to act as his agent or representative. Without making it complicated, delegated legislation can easily be defined as it is a power which a legislature delegates over to executive or some subordinate body to perform its function, that is of lawmaking. Like as we all know that there are three main bodies of the government: legislature, executive and judiciary. Now, there is a concept of separation of power which is followed in some countries strictly and in some countries it is not followed strictly. So as legislature has a function to function to make law, it cannot be expected to make laws in every field and in every extent of it. So what legislature actually do is delegate some of its limits of that power to the delegated body, that may be executive or the subordinate legislature. So, delegated legislation is also known as a subordinate legislation, secondary legislation, ancillary legislation, or administrative legislation, and the legislature makes enabling act, which is also known as a parent act, under which delegated legislature get its power to make laws. Moving to the slide number 2, delegated legislation under the Constitution of India. Now, there is some historical background that how delegated legislation actually came to the India. So it is followed from the Charter Act of 1833 when the East India Company was recapturing political impact in India. Now the Charter Act of 1833 vested the administrative powers only in the hand of Governor General in Council, which was an official body. He was unable to make law and guidelines for revoking, correcting, modifying any law or guidelines which were for all people regardless of their nationality. Then in 1935 came Government of India Act 1935, which was passed and which contained the serious plans of delegation. After that, a constitution came after independent India, and as we all know, Constitution of India contains 400 plus articles, so it won't be a surprise that if it constitution makers include some solutions for it. So basically what solutions I'm talking about is that we all know that legislature, executive, judiciary has their separate functions, but there need to be some correlations between them for the smooth functioning and better functioning of the government. So, in the case of Queen versus Bora, which was the case before independent India, where actually Privy Council held that the imperial legislature delegates its power to Parliament, Indian Parliament, so it cannot delegate its power further on. So, Privy Council in case held that Council of Governor General was supreme legislature and has ample number of powers, and who are entitled to transfer certain powers to provincial executors. But what it said that Parliament of India can only delegate some of its power which is reasonable or condition based. So according to Privy Council, Indian Parliament doesn't have a absolute power to delegate its lawmaking power. Okay, then came our constitution. So specifically, it's not mentioned anywhere that legislature can delegate its power, but it can be interpreted like from the article 312 in the Indian constitution, where Rajya Sabha has power or right to open a new branch of all India service with a majority of two-third majorities vote. This means that some power of legislation will be delegated to the new recruiter of all India service. There are many cases through which delegated legislation under the Indian Constitution of India can be understood. So, this was the basic historical background of delegated legislation in India. Then comes reason for growth of delegated legislation. So now when we comes to the reasons for the growth of delegated legislation, first and foremost comes is the pressure of time upon parliament. Now there are area, scope and horizon of state activities which are expanding day by day, and it is difficult for the parliament to make laws on each and every matter as they're having a lot of work to do. So they and also they also have to make a legislation on various matters. Like the parliament is so much occupied with matters concerning foreign policies, political issues, that it has not much time to enact the laws in details. So it only frames the broad part of the rules and outlines of the legislation and give that legislations to the executive or some of its subordinates to fill the details and make the necessary rules and regulations. Okay, so to reduce that pressure of time on the parliament, we delegate legislature delegate its lawmaking function to the executive. Then comes technicality in the matter. What do we mean by the technicality is that we cannot expect legislature to know every know have knowledge of every field. Like with the progress and advancement in the society, things have become more twisted, complicated and technical. So to understand the technicality of each and every topic, legislature needs the expert of that particular topic who is well aware of each and every details of the matter, so as to avoid some loopholes which can be caused. Over the years, it has been observed that some legislatures only know politics and some might have knowledge about one or two topics but not every field. Therefore, after framing policies by the parliament on any topic, that topic is given to the government department or any particular person who knows about that technicality of that particular topic and given the power to lay down the details. Then, the next reason for the growth of delegated legislation is flexibility. By flexibility, parliamentary amendments is very slow and it requires a process to make any type of law. But by the tool of delegated legislation, it can be made expeditiously with the help of executives. Like example, police regulations, bank rate, import and export, foreign exchange, etc. Also, Parliament cannot foresee the contingency while enacting a law. So, to make it foresee the workload is being given to the executive. So, it is necessary to give work to a lower body to have that work in a smooth and better manner. Like, we cannot expect legislature to make law in every matter, and not only to make the law for that matter, but also to know the impossibility and practicality of that issue. So what actually legislature do is that may he it makes the guidelines for it and then pass it to the executive to make the proper laws or rules and regulations in a manner how to impose them. Then comes emergency. Like in type of emergencies, one should know how to deal with it quickly without any delay. Legislature is not equipped with the skills of providing an urgent solution to meet the situation of emergency. Delegated legislation is the only way to meet that situation. Therefore, in times of emergency and war, an executive is given a wide power to deal with that situation. Like as we know in Indian Constitution as well, President becomes the main head of all over the country during the time of emergency. Also, it can be seen like in the example of England during the First and Second World War, the Defense of Realm Act 1914 to 15 and Emergency Power Act 1920 with the biggest example. Also, like in cases of inflations and flood, epidemic, economic depressions, etc. Like in the current situation as well, the pandemic situation, it is the executive which is coming to the power which is it is the executive which is coming to the power and actually enforcing the laws at this time of emergency. Then comes experiment. Experiment, practice of delegated legislature, enables the executive to experiment. Like it can be understood with the example of traffic rules. Legislature make laws for the traffic guidelines, but how to enforce those laws on policies actually, executive implement those inflicting fines and enforcing those laws in a manner they think it can be practically imposed. How so traffic in traffic matters of the road, an experiment method can be conducted, and in wake of its application, necessary changes can be made in the provisions, like inflicting higher fines. And at this recently, it was an type of an experiment which executive imposed, and it came to be a successful experiment. But legislature can't do it every time. So this is how legislature delegates its power to the executive for the experiment. Also come to the complexity of modern administration. Modern administration used to take added responsibilities when it came to appraise the conditions of the citizens, such as looking after their employment, health, education, regulating trade, etc. Therefore, the complexity in the modern administration and expansion of states' function to the social sphere and economic have allowed the formation of a new form of legislation and to give wide power to various authorities on various occasions. It is important that an administration should give an excess of power to activate social economic policies. In a country like Bangladesh, where control over private trade, business, or property may be required to be imposed, it is necessary that the administration should hand over the excess amount of power to implement such policies. So, these are few basic reasons for the growth of delegated legislation. Also, like in a matter of technicality, there are many times the legislature don't know the field, so it leaves the blank on the main law and give it to the executive to fill those details. Okay, now next comes constitutionality of delegated legislation. So when we comes to the constitutionality of delegated legislation, let's first understand the position of USA. Like, delegated legislation is not allowed theoretically in the Constitution of USA because of two reasons. First is separation of power. As separation of power is strictly followed in American Constitution, like legislature, executive, and judiciary cannot interfere in any of the other functions. Hence, separation of power is strictly followed and delegated legislation is not followed in American Constitution. Also, the second reason is delegate is non-potest delegate, which means that delegated body itself cannot delegate its power to further subordinate body. Like in USA, Congress was itself a delegate, then how can it delegate its power? And the political theory that was propagated by philosophers like John Locke and Montesquieu, which were the main framers of the American Constitution. Like Montesquieu is the compounded of separation of power, and then John Locke has said that a legislature cannot delegate his power of lawmaking to any person or cannot place it anywhere. He further stated that there should be a separate legislature and executive because if the power of lawmaking and execution of that law go in hand go in a one hand, it can be misused, and these people use that power to exempt them from that law and use it for their private advantages. Hence, uh, uh, delegated legislation is not constitutional in American Constitution. Then comes position in England. Now, the doctrine of parliamentary sovereignty is the core element of UK Constitution. So, in England, the Parliament is supreme and there is no limitation by the Constitution on the Parliament. Also, Parliament in England has wide powers of delegating its legislative power to the executive or other subordinate bodies. So, in short, we can clearly say that delegated legislation is completely possible and constitutional in England. Then comes position in India. Now, position of India when comes to constitutionality of delegation legislation can be seen in various cases. Pre-independence, as we previously did, Queen versus Bora case. Previously, it was only the conditional legislation which was validated by the Privy Council, and therefore delegated legislation is not permitted as per its reasoning in pre-independence India. Then comes post-independent India. Now, post-independent India, Constitution of India does not provide the same position as the prominent British Parliament provided to the delegation of legislative powers, and also how far delegation is permissible has got to be confirmed in India as matter of constructions from the expressive provisions of Indian Constitution. Now, it was interpreted by the judiciary in various cases that what extent is India perform delegated legislation. So, in case of Raj Narayan versus Chairman, Patna Administration Committee, the Supreme Court of India upheld the delegation of power given to the executive by the legislature, but does not exactly mention how much delegation can be made. So, so the constitutionality of delegated legislation can be tested through three main I may say it's a process or test. So first test can be a violation of Constitution of India. Is the delegated legislature or legislation has violated the Constitution of India? If it does so, then its constitutionality can be challenged and it can be declared invalid. Then second comes is it in the violation of Enabling Act. Now Enabling Act is the one which empowers the subordinate to have a delegated legislation power. Now, if that delegated legislation violate is in violation of Enabling Act, then again its constitutionality can be challenged and can be declared invalid. And then third comes is the violation of principle of natural justice when the statute itself provides of such requirement. Now, when Enabling Act mentions that what is the power of delegated legislature, and if it is within its power but it make laws for something which are not reasonable or which are beyond not reasonable, or it can be said that it is no sense to the Enabling Act or the Parent Act. Like delegated legislation has to be in sense or in the limits of the Enabling Act. But if it is beyond it or it is irrelevant to that Enabling Act, then it can again be declared unconstitutional and invalid. Then comes classification of delegated legislation. Now, there can be few classifications of delegated legislation. Like first can be power to bring act into action. Now, delegated legislation doesn't always have to make some further laws for it, but it can only be limited to for imposing those laws. Like legislature had made some laws and executive has to impose or execute those laws and can only make laws for that execution and not for any other thing. Then comes conditional legislation. Conditional legislation is basically when Enabling Act puts some conditions over the delegated legislature which delegated legislation cannot cross, like power to fill in the blanks of the format. Like as we previously read that about the technicality matter, legislature makes some law, doesn't know actually full knowledge of that field, so it can keep some blanks over that and give it to the delegated legislation to fill it, and the delegated legislation only has right to fill those legislation blanks and nothing else. Then comes power face in removing difficulties. Now, legislature makes some laws and executive has to impose it, but there might be some situations or situations when the itself Enabling Act becomes an obstacle for execution of those laws or for imposing those laws possibly successfully. So what delegated legislation sometimes get power is to remove those difficulties from the Parent and Enabling Act and execute it practically and successfully. Hence, these are the few classifications of delegated legislation. So here we end up with the delegated legislation, and soon I'll post the next video on the control over delegated legislation by Parliament, Executive and Judiciary. Thank you.